In this bulletin, an attorney speaks out against unfair patent laws in the United States. Hello, I'm David Gibbons and here is the news. A Washington DC based attorney who has filed a brief with the US Federal Circuit says unfair patent laws should be overturned. Merritt Blakesley prepared one of the amicus briefs to be considered by the full bench hearing of the Federal Circuit on October 2. The rare en banc hearing, with all 17 Federal Circuit judges attending, will consider changing or upholding the restrictions on two existing patent laws. And Merritt Blakesley joins me online. Thanks, Merritt. Let's start with some basics. Can you tell me and our audience just what is an amicus brief?
An amicus brief, amicus is short for amicus curiae, which is, of course, Latin for friend of the court brief. When the Supreme Court or courts of appeals are faced with an issue of more than ordinary importance, they often invite the legal community and industry to submit friends of the court briefs to assist them in thinking through a difficult issue. And so these issues, these briefs tend to be submitted by law professors, by professional associations, and particularly by members of industry. They tend to add depth to the legal analysis, and the ones submitted by industry play a crucial role in providing the courts with an understanding of the real-life effects that their decisions potentially can have.
So tell me, Merritt, why is an en banc hearing so significant?
Typically, courts of appeals, like the Court of Appeals for the Federal Circuit in Washington, where this matter is being heard, hear appeals with a panel of 3 judges. But in cases where the court believes it has before it a case of extraordinary significance, they will, in a situation like that, ask that the issue be considered by the entire bench of the court. It's long. And in the case of the Federal Circuit, this is 17 judges, all of whom will be present at oral argument, all of whom will read the briefs, and all of whom will vote on the issue. In this case, the court's being asked to overturn 2 of its previous decisions. This is obviously an appeal of considerable moment, and therefore it's not surprising that they should have chosen to hear this en banc.
So are you expecting many amicus briefs to be filed? I mean, we've already heard that there have been 20 filed in support of one particular argument. Are we expecting many more? I mean, what's happening here?
Well, it's hard to know, but I think it's quite likely that there will be a nearly equal number, maybe more, maybe less, filed on behalf of the other party. The briefs that have come in so far, and as you say, there are 20 of them, have been filed on behalf of the position of Impression Products. The briefs in support of Lexmark's position need not be filed for another 30 days. And since there have been nearly 20 on behalf of Impression, it's predictable, foreseeable that there'll be as many on behalf of the other side as well. In addition, the Solicitor General of the United States will be filing a brief in about 10 days. This was as part of the court's decision to hear this en banc. They also, in addition to issuing a general invitation for amicus briefs, they issued a special invitation to the Justice Department to file a brief explaining the government's position on these 2 issues. And that'll be filed by the Solicitor General.
That's a lot of amicus briefs, 20 on one side and possibly 20 or so on the other side. That seems to me to be as rare as having an en banc full bench hearing itself.
It's certainly unusual to have that many briefs. As I said earlier, courts are nourished by the positions that are brought before them by the lawyers representing the parties, and then in a situation where they're amicus briefs, their understanding of issues is further enriched by these briefs. And here, they'll be very heavily enriched by this enormous number of briefs. And again, that's consistent with the importance that the court attaches to getting its resolution of these two issues right.
So tell me, Merritt, why do you think that these existing patent laws should be overturned?
I think that the existing patent laws, and particularly the one that I've been concerned with, the Jazz Photo issue, is fundamentally unfair. The Jazz Photo issue says that, well, let me back up for a moment. The normal rule in patent law is that if I sell you a product that I've made pursuant to my patent, once I've sold that to you, I've lost all my right to control what you do with that particular product. I still retain my rights in my patent, but as to that particular article, I have essentially abdicated any ability to control what you do with that product afterwards. Now, in our situation, the patent holder is Lexmark. The patented articles are toner cartridges, and the rule today is, and the rule in my view has been that has been the rule for nearly a century and a half, is that once those objects are sold, Lexmark's rights in them are gone. But the 2001 decision by the Court of the Federal Circuit, which is one of the issues that's on appeal right now, held that that rule, the patent exhaustion rule, only applies if the Lexmark cartridge is first sold in the United States. If the Lexmark cartridge is sold outside of the United States, then Lexmark retains its right to control what you or I do with that cartridge once it comes back into the United States. And as anybody who's familiar with the remanufacturing industry knows well, this has been a significant impediment to the remanufacturing industry being able to sell cartridges into the United States. Now, I believe that rule is unfair to consumers, and I think it is a misunderstanding of what the law has been really going back nearly 150 years in this country. I think the Jazz Photo decision was badly decided. I think it was an anomaly, and I think it's an anomaly that works in unfairness on consumers.
Merritt Blakesley, thank you for joining me.
Okay. Thank you, David.
The issue at hand may be over printer cartridges, but it has a far-reaching impact on other industries as well. As a non-US resident, for example, if I take my smartphone into the US, I'm technically or legally not able to repair it there under existing laws should it break. For more breaking news, go to irecyclingtimes.com or grab a copy of Recycling Times magazine, published in 5 languages every month. This month, European-based Giovanni Giusti from DocSense is on the front cover, warning imaging CEOs to adapt or die. Thanks for watching. See you again soon. I'm David Gibbons.